Title 12, Close Corporations. Section 95 talks about the definition of a close corporation, and it is one whose articles of incorporation provides for the following under letters A, B, and C. Why did I highlight the articles? Because any person who is claim or individual or entity who is claiming that a certain corporation is a close corporation must present as evidence the articles. Without the articles, there is no basis for stating that a corporation is a close corporation. Again, in other words, the requirements under Section 95 must be met for a close corporation to be considered as such. The second paragraph talks about corporations that cannot be classified as close corporations. For those of you who are looking into Attorney Lacos notes now, he uses the cute moniker ICOM BSP. Excuse me. Yeah. ICOM BSP. Also note that since the last sentence of that second paragraph says and corporations declared to be vested with public interest, we must correlate this to Section 22. Therefore, other corporations that cannot be organized as close corporations would be quasi-banks, other financial intermediaries like pawn shops, pre-needs, and trust companies. Mere ownership by a single stockholder of all or nearly all of its capital does not make it into a close corporation, again, if the requirements under Section 95 are not complied with. So if there's one thing that you should remember, it's Section 95 when it comes to close corporations. A close corporation can be a family corporation, but a family corporation is not necessarily close, because again, Section 95. So for those of you who are reading some cases or who have parents or lawyers or who just happen to know, the Supreme Court has mentioned that a family business that is run in an informal manner is considered a de facto closed corporation. But for purposes of this course, let's just stick to the fact that not all family corporations are automatically closed corporations. A closed corporation sometimes is treated as an incorporated partnership. When you look at sections 99, 100, and 104, which we will discuss shortly hereafter, the difference between a closed corporation and a partnership is that one, it has a stronger juridical personality. Two, there is still stockholders' limited liability. And three, the directors and officers are still not personally liable for corporate acts. But we will discuss later on under the next sections as to what types of acts directors and officers will be personally liable. I want to show you a table showing the differences between an ordinary corporation and a stock corporation. So just please take a picture of this and just read it on your own. So there are 7. This is for the first table, and this is for the second table. Although you don't need to buy it, I'm just plugging it in. This is the book that I'm using with him, taking pictures of the tables so that I will not be sued for copyright infringement. The corporation, when you talk about 20 here, sorry. If you look at letter A, there can be actually a particular number of people as long as it's not more than 20. Any amount in excess of the stated amount can lead to the corporation refusing registration of any transfer that would result in a greater number than 20 or a greater number than that specified in the articles. So for example, there are already 20 shareholders and one of them dies, and the heirs of that shareholder are, say, 10 or even 2. So admitting those 2 heirs would necessarily make it 21 in excess of what is legally allowed. In that case, then the heirs have 2 options. the shares may be placed in the name of one who will be the nominee, or two, a corporation can be organized by the heirs to hold all the shares. Just be careful, because under the law, if you read the code, if a corporation holding a stock in a closed corporation is a non is not a closed corporation also, then the main corporation we're talking about is not considered a closed corporation. I hope it makes sense. If you see in the last paragraph, a corporation shall not be deemed a close when at least 2/3 of its voting stock is owned or controlled by another corporation. So just take note of that. There is a difference when you talk about closed corporations and closed corporation and a closely held corporation. When you say closed, it emphasizes on the determination on the part of the participants to keep outsiders from acquiring any interest. So, in a closed corporation with the letter D, closed, the shares are transferable but by agreement. Whereas in a closely held, you're focused more on the number of shareholders in a corporation at that particular time. So, you're talking about the fact that at a particular moment, there are just a few. So it's just more of a description. Let's continue to section 96, Articles of Incorporation. So these are the things that may be included, not necessarily required. So the article still must comply with the requirements of section 13. So just take note of that. Do not forget that even if it has a separate provision under Title 12, closed corporations must still comply with the requirements of Section 13. Okay. Section 97. I won't discuss Section 96 anymore because it's relatively self-explanatory. Validity of restrictions on transfers of shares. So, first of all, they must appear in the articles. Okay, in the bylaws and in the certificate of stock. So it must be in 3 documents. Otherwise, it is not binding on a purchaser in good faith. What does it mean? Even if it's not on all 3, say it's in the articles and it's in the certificate of stock, but it's not in the bylaws. If a purchaser is someone who knew, they cannot say, oh, it's not in all 3. They would be considered in bad faith kasi they already know that there are restrictions and yet they decided to buy it because they're trying to they're trying to circumvent it by saying, oh, it's not in the bylaws. They're going by technicality. So here the law already provides it's not binding only for those purchasers in good faith. Okay, so the restrictions have limits themselves. Any restriction shall not be more onerous than on the original or the existing stockholder. So what are the restrictions? If you look at Attorney Lacos' notes, these are the right of first refusal and the right of first option, or what we call the preemptive right. So again, what else is a restriction? Although there can be restrictions held here, there cannot be an absolute restriction against a transfer of shares. Because that would inevitably be, kumbaga, a forfeiture of any right to transfer. Diba? Hindi naman pwedeng absolute. So when we talk about Section 98, what are the effects of issuance or transfer of stock in breach of the qualifying conditions? And these are the ones stated in Section 97. Also under Section 95, no? If you look at A, B, and C, what is common is that there is a conclusive presumption of notice. What does that mean? Whether or not you actually know does not matter. The fact that the conditions under A, B, and C are complied with means you are expected to know. So in our letter A, as long as it is stated in the certificate, the qualification for eligibility to be a holder, then you are presumed to know. Under letter B, there are 2. It must be stated in the articles and in the certificate. In letter C, you will also note that it must be stated, the restriction must be stated in the stock certificate when you talk about any other restriction. So, again, I will repeat, as I mentioned earlier, the effect is that a corporation may, at its option, so it's not necessarily required, refuse to register in the name of the transferee. So, what are the instances that letter D is not applied? These are under letter E. Okay, meaning the corporation must register. It cannot refuse registration if A, it has been consented to by all the stockholders, or the articles have been amended in accordance with the title. Okay. Before I continue discussing Section 98, I'll just jump to Section 99 so that they're discussed together. And Section 99 talks about the agreements by stockholders. So these refer to private agreements. If you read the provision, it does not talk about what needs to be stated in the articles, no? So it's a separate agreement between the stockholders themselves. Like in letter D talks about the proprietary rights of partners to manage the partnership. And letter E, if I may just move, talks about the mutual agency, which is a feature in partnerships. So you will see that in closed corporations. Let me just summarize. When you talk about Section 99, you're talking about a pre-incorporation arrangement under paragraph A. So it's a pre-incorporation arrangement. Let's write it down in abbreviation. Letter B, a voting agreement, and the agreement on the conduct of corporate business and affairs under letters C, D, and E. So these three talk about the conduct of business. So sections 96 and 99, if I may discuss them together, recognize the right of stockholders to manage the business and affairs rather than the board. Okay, this is one of the key features of a closed corporation as distinguished from other types of corporations. It's the integration of ownership and management. So even if there is an integration between ownership and management, let me just emphasize that stockholders are not automatically liable for corporate debts and obligations. Of course, it is still a valid corporation. Therefore, it enjoys limited liability. Because of this integration in ownership and management, Section 11 already provides that there are instances when a board meeting is not necessary, or it can be informally or improperly held, no? So it is deemed valid if the conditions under letters A to D have been complied with, like written consent of all the directors under letter A, actual knowledge, and acquiescence, meaning they did not object. No prompt objection in writing. What constitutes prompt objection would depend on the circumstances of the case. That's why the law did not particularly provide like a specific number of days to make an objection. So, an action under the last paragraph, if it's within the corporate powers, meaning not ultra vires. If it is without proper call or notice, it is deemed ratified by a director. If they have knowledge but did not file a written objection with the secretary of the corporation. So, even if there is Section 11, the general rule requiring board meetings is still applicable to closed corporations. Section 11 is just the exception to that general rule. Let me discuss sections 101 to 104 together. Section 101 talks about the preemptive right in closed corporations, and it includes reissuance of treasury shares. Section 102 talks about the amendment of the Articles of Incorporation, which requires 2/3 vote. Please note, regardless of whether the stockholders have or do not have voting rights, or there can be a greater proportion of shares as may be specifically provided in the articles. It's okay if there's more than 2/3. And the Section 103 talks about deadlocks, where the stockholders or the directors are divided, so much so that a corporate action cannot be obtained, no, or it cannot anymore move forward, kaya nga deadlock. So this talks about a written petition to the SEC by any stockholder. So this actually gives the SEC the power to arbitrate. Again, arbitration is a mode of settling dispute as outside of the judicial system. Please also note that under letter D, when there is the power of the SEC to issue appropriate orders, such as requiring the purchase of the shares of any stockholder, most likely the ones who are requesting to opt out, regardless of the availability of unrestricted retained earnings. So this will be an exception to the limitation that there must be unrestricted retained earnings when we talk about the appraisal right. Obviously, the people who will want to opt out are those who are effectively exercising their right of appraisal. So this section also talks about a provisional director who must be an impartial person. Okay? And the director is not a receiver, or neither is he or she a custodian. They will just be literally a director in the interim. And Section 104 talks about withdrawal of the stockholder or the dissolution of the corporation. So in this case, any stockholder may, for absolutely any reason, compel the corporation to purchase their shares held at fair value. Okay? As long as there is sufficient assets to cover debts and liabilities. Note, what is required is that the corporation has sufficient assets, not necessarily unrestricted retained earnings. So, what about dissolution? Any stockholder may file again a written petition, much like arbitration. Any stockholder can file a written petition to the SEC to compel the dissolution, but only for particular instances. If there is illegality, fraud, dishonesty, or oppressive or unfairly prejudicial conduct by the directors, officers, or those in control. Or when the assets are not speculatively, actually being misapplied or wasted. As an example, let me just read an example given by Aquino. If 10 classmates, all graduates of a particular school, decided to form Gatas at Iba Pa Inc., the principal purpose of which is to produce, package, and sell Carabao's milk. If, for example, Mr. Sakit Ulo, one of the 10 classmates, disgruntled at the way the affairs of the corporation was being handled, demanded that all 10 stockholders meet to elect directors. And Ms. Sakit Chan sued all 10 classmates stockholders for damages for violation of the Food, Drugs, and Cosmetic Act because there was a cockroach found in the milk she drank. Number one, can Mr. Sakit Ulo demand a stockholders meeting to call the directors? The answer is no. Under Section 100, they are allowed, under Section 96, they can provide that the business of the corporation be managed by the stockholders rather than the board. So that is under Section... Section 96. No? And then for letter B, does Ms. Sakit Chan have a cause of action against the corporation? The answer is yes. Because stockholders who are managers of the closed corporation are liable for corporate torts. You will see that in the previous provisions under this title. So, because they are liable for corporate torts, they are made personally liable unless there is reasonably adequate liability insurance. And it's stated also there in the title. So, negligence need not be proven to warrant liability by manufacturers of foodstuff. This is in relation to the new civil code. Don't worry, I won't ask it in the quiz. So that ends Title 12. And I'll see you in Title 13.